week, the tribunal received a petition from counsel for the defendant, Nuremberg, inquiring as to the result of a previously ordered physical examination to determine whether he was able to stand trial. It seems that an order to that effect was made by the executive presiding judge before this tribunal was organized. For some reason, the result was not announced. The tribunal would consider and determine that question with respect to all documentary evidence, without regard to whether specific objection had been made to its introduction, but that both prosecution and defense would have a full opportunity to be heard upon all such questions in the final arguments and briefs.
Of all the names which have become associated with the Nuremberg trials, I suppose that none has been a household word for so many decades, indeed for nearly a century, as that of Krupp. Today, the name Krupp is freighted with associations and preconceptions. For some people, it is the name which heads the list of arms makers: Schneider, Creusot, Vickers, Skoda, and others, who, it is said, stir up wars, and with a zeal which transcends mere patriotism, arm all the legions of Mars with terrible impartiality. Not seek in this case to level any attack against the business of making arms as such. We are not trying to prove that all wars derive from the sinister machinations of armament manufacturers and their sales agents. The armorer's trade is no more inherently unlawful than that of the soldier or the diplomat. All of these professions revolve around war and statecraft, but that does not make them criminal per se. Furthermore, the individual defendants in this case are not being prosecuted for the sins of others, or because the name Krupp has acquired over the years a sinister sheen. The men in the box are not symbols, nor are they charged as representatives of other men. The men who rose to power by riding the crest of the Nazi wave. That most of the defendants were members of the Nazi Party is a significant fact, but it is not part of the basic framework of this case. Nazism was, after all, only the temporary political manifestation of certain ideas and attitudes which long antedated Nazism, and which will not perish nearly as easily. In this case, we are at grips with something much older than Nazism, something which fused with Nazi ideas to produce the Third Reich, but which has its own independent and pernicious vitality. We cannot, therefore, comprehend the actions or judge the guilt or innocence of these defendants without some familiarity with the setting in which these acts occurred. But that history will shed much light on the motives which led the defendants to do the acts with which today they are charged. In opening a case of such historic import as this one, there is a natural impulse to dramatize the occasion by ringing all the changes on the name Krupp, which was described 2 years ago by Mr. Justice Jackson as the focus, the symbol, and the beneficiary of the most sinister forces engaged in menacing the peace of Europe. The acts and events on which the charges in Count 1 are based began nearly 30 years ago. The earlier history of the Krupp firm is important only as background, and we will sketch it in at this time in the briefest manner, only for the purpose of clarifying the scope and nature of the Krupp firm at the end of the First World War, when the story of this case begins. The firm of Friedrich Krupp was founded in 1811 as a small cast steel foundry in the city of Essen in the Ruhr. The firm retained its family character throughout the early part of the 19th century. When Friedrich Krupp died in 1826, he was succeeded by his eldest son, Alfred, to the male line in 1902. The proprietary management of the firm passed to his widow, and the heiress was his 16-year-old daughter, Bertha Krupp. Pursuant to Friedrich Alfred's will, the Krupp firm at this time was reorganized into a private, limited liability company, Friedrich Krupp Aktiengesellschaft, with a stock capitalization of 160,000 shares, valued at 1,000 marks each. All but 4 of the shares were held by Bertha Krupp. and the remaining 4, distributed only in order to comply with legal requirements, were kept under careful control. In 1906, Bertha Krupp married Dr. Gustav von Bohlen und Halbach. The Emperor Wilhelm II conferred upon the bridegroom the right to use the name Krupp. Expansion of the Krupp enterprises continued right up to the outbreak of the First World War. 1981 stringently limited the size of the German Navy, and Article 190 specified the rate at which the authorized naval units could be replaced. Article 191 forbade Germany to construct or acquire any submarines whatsoever, even for commercial purposes. The above and other comparable provisions of the Versailles Treaty were to be enforced by Allied control commissions